Good morning. Thank you very much for joining us for our quarterly legal and compliance update for block managers. We're expecting about 400 people to be joining us over the course of today's webinar, and we have a huge amount to cover off. We're going to do our very best to focus in on the parts that really matter, but there have been some really interesting and important cases that we're going to cover off, particularly around ground rents and Section 20. The Building Safety Bill is now the Building Safety Act, and there is a huge amount of information already available and more coming, so we're going to focus in on that, and we're going to start off today with a primer. The primers are designed for people to really get to grips with core elements of block management. They've been well received in the past, but if you don't find anything useful, we want to hear from you. So at the end, take a moment, fill in the comments, let us know what's working, what's not working. We do this to help you, so if it's not right for you, or if it is right, please take a moment to tell us. If you want to interact with us during the course of today's webinar, whether to provide a comment, insight, or even a question, please do so via the Zoom panel, which should be available on your screen. We will get the questions moderated by my wonderful colleague Remy, and we will have 10 minutes at the end to go through as many of them as possible. We will do our very best to keep to time. Usual disclaimer, so all of today's information is for general information purposes only. It does not and must not be taken as legal advice or official guidance, although I'm sure if you want specific legal advice on the facts that you are facing, our wonderful guest today would be delighted to oblige, and her contact details will be available to you in the follow-up email. And also, amazingly, we've managed to embed LinkedIn QR code to get your phones ready, so you'll be able to connect with me and our wonderful guest directly on LinkedIn as well. And so over to our wonderful guest. I keep calling you wonderful guest because I wanted you to introduce yourself. Cass, could you please give us a brief introduction?
Good morning. Happy sunny Tuesday morning. Cassandra Zanelli, solicitor and CEO at Property Management Legal Services.
Amazing, thanks. And thank you very much, Cass, again, for giving up your time in preparation for today and for presenting a huge amount of information that we've got coming down the track. So starting with our primer, RTM. What is an RTM? How do you form one? What are some of the challenges? Could you please, I guess, take us back to school and give us a high-level overview?
Absolutely. And this comes on the back, doesn't it? We talked, I think it was either last time or the time before, about the recent, it must have been last time, we talked about the recent Supreme Court decision in First Port and Settlers Court, and that generated a lot of questions. So on the back of those questions, listening to the feedback, we thought we'd do just a 10-minute introduction to right to manage. So since its introduction under the Common Hold and Leasehold Reform Act 2002, many lessees, or qualifying tenants as they're called under the legislation, have taken control of their block and the management functions in relation to their block by acquiring and exercising the right to manage. If leaseholders meet the qualifying criteria, and there's some quite strict qualifying criteria set down by the Act, then they have a statutory right to exercise the right to manage in relation to their premises. So this differs from some of the other ways in which lessees gain control of their building, and it's not based on any fault on the part of the existing manager, whether that be the landlord or a named manager in the lease. It's purely subject to meeting the qualifying criteria and getting your paperwork right. It's purely the exercise of a statutory right that leaseholders have to take control and to exercise the right to manage their building. And by acquiring the right to manage, the RTM company takes over what are called management functions in relation to the premises. And those management functions are functions that would have been exercised previously by either the landlord or the named manager under the terms of the occupational leases. And the Act defines what management functions are, just in case there's any doubt. And it talks about management functions being functions with respect to services, repairs, maintenance, improvements, insurance, and management. So essentially, and this is a simplification, but essentially the RTM company become responsible for the provision of services under the lease. They step into the shoes of the landlord or the named manager, depending on what that occupational lease or those occupational leases look like. I touched on the fact that the the RTM company need to satisfy the qualifying criteria, and these are the criteria set down by the Act. So to be eligible for the right to manage, the building itself must meet certain conditions. So it must either be structurally detached or a self-contained part of a building. And you'd think that you would be able to look at a building and understand whether or not it qualifies for the right to manage, whether it is structurally detached or whether it's a self-contained part of a building. But there have been numerous cases in front of the upper tribunal, all to deal with right to manage. I have to say the amount of case law that right to manage has generated is frankly eye-watering sometimes. I think a judge a few years ago referred to it as being akin to trench warfare. And I suspect that that's how it feels if you are involved in any of those cases. But in addition to the building qualifying, then there are set another elements of qualifying criteria as well. And we'll set all those out, Raj, won't we, in the ebook that follows this. But you what?
So an ebook will follow with lots of detail, but I think just one of the points that you touched on a moment ago was obtaining the right to manage. I'm sure lots of people on today's webinar already get this, but that does not oblige them to manage directly. They are able to outsource the management function. So I think that's just an important sort of distinction or clarification for people who are relatively new to the sector.
Absolutely. It's not uncommon for the right to manage company to acquire the right to manage because they're the ones who have the locus to do that. And then for them, in the usual way, to instruct a managing agent to assist them in the management of their building. Again, that's perfectly normal for them to do that. Some will self-manage, as some other lessee-owned and controlled blocks self-manage, but others will outsource that to a managing agent to act as an agent on their behalf and to assist them in the management and the exercise of those management functions. But one of the big things with RTM is getting sufficient support. So once you have formed your RTM company, and any number of qualifying leaseholders can incorporate the RTM company, the first thing that you do thereafter is to invite all other leaseholders to become a member of the company. And you do so by sending a notice inviting participation. And that's sent to all other qualifying leaseholders who aren't already members or indicated their intention to become a member of the company. The notice has to be in writing, and there is a prescribed form that must be used. I see a number of RTM companies or acquisitions of the right to manage fail because the correct forms aren't used. So it is important to make sure that the prescribed forms are being used when an RTM company is seeking to acquire the right to manage. And the RTM company need to get sufficient support. There's a threshold of half or 50% that the RTM company need to meet in terms of qualifying leaseholders agreeing to participate in the right to manage. So once that threshold is met and 14 days has passed following service of the notice inviting participation, that's when the claim notice is served on landlord, appointed manager under Section 24, or any other party other than landlord or tenant under the terms of the lease. The claim form, in the same way as the notice inviting participation, is in a prescribed form. So it's really important that the notice of claim is given in that prescribed form and given to the correct parties as well. Again, there's been a lot of case law generated in relation to that because any failure is likely to affect the success of the claim. The notice of claim will allow a period of 1 month for the landlord and any other party who's received the notice of claim to respond by serving a counter notice, and that counter notice will either admit or dispute the acquisition of the right to manage by the RTM company. Now, if no counter notice is served, or if the right to manage is admitted to a counter notice served saying, yep, we accept you can acquire, then management passes to the RTM company on the acquisition date that's been set out in the notice of claim. I see, and indeed that the tribunals have seen, some issues that have arisen. So I thought we'd spend a couple of minutes just looking at some troubleshooting on some troubleshooting tips in relation to right to manage, because there's a lot of case law generated. So if we can help and avoid you being the next caution retailer in the upper tribunal, or indeed Supreme Court, then all the better, I think, Raj.
Yes.
The first one is, how many RTM companies are needed? And we know the answer to that because there was a Court of Appeal case a few years ago now that ruled that it's one RTM company per block. So an RTM company can only acquire the right to manage a single building. So if you have, for example, an estate that's comprised of 10 structurally detached blocks, then you're going to have potentially 10 RTM companies with each block needing to qualify and follow the procedure individually. The second point that comes up quite a bit is what costs the RTM company is going to be liable for. So in addition to its own costs, because there are going to be costs, there's going to be costs for incorporation, costs for professionals or lawyers if you instruct, the RTM company instructs professionals or lawyers to act on their behalf. But in addition to their own costs, the RTM company is also going to be liable for the reasonable costs of the landlord, or indeed anybody else they've given a notice of claim to, in consequence of the claim notice. Now, if the right to manage is disputed, then the tribunal holds jurisdiction to determine whether or not an RTM company is entitled to acquire the right to manage. But just before we move on to look at that bit, in relation to costs, if the right to manage is disputed and an application is made to the tribunal who determine in favour of the landlord, so say to the RTM company, no, you're not entitled, or if the RTM company withdraw their application, then the RTM company is going to be on the hook for the landlord's reasonable costs associated with those tribunal proceedings. So it's important that that's flagged so that the members of the RTM company know what their potential liabilities or potential exposure is in relation to costs. I touched on there what happens if the right to manage is disputed. If the RTM company receive a counter notice disputing the right to manage, then it can make an application to the tribunal, and the tribunal have jurisdiction to determine whether or not the RTM company is entitled to acquire and exercise the right to manage. Now, because this is a non-fault based right and statutory right that leaseholders have to form an RTM company and to acquire the right to manage, the grounds on which a claim can be disputed are quite limited, but they do tend to be really technical grounds on which the right to manage is disputed. There was a comment a few years ago, I think I mentioned it, that it can seem a little bit like trench warfare sometimes in relation to why things are being disputed. Handover of funds is an issue that seems to be getting a bit more regular. I've certainly had a few cases across my desk recently in relation to this, because when the RTM company acquire the right to manage, the landlord or manager or named manager in the lease should transfer the accrued uncommitted service charge funds to the RTM company. And it's section 94 of the Act that sets out what that means and what accrued uncommitted service charge monies are. But that duty must be complied with on the acquisition date or as soon after that date as is reasonably practicable. I'm seeing that that's not always happening as it should be happening. And if that isn't happening or hasn't happened, then the RTM company can make an application to the tribunal, because the tribunal retain jurisdiction to determine what accrued uncommitted service charge monies should be transferred across. And in that kind of application, there might also be an invitation to the tribunal judge to double hat and to sit as a judge of the county court as well. I find that happens from time to time. And the last one, the last troubleshooting tip to mention is what premises the RTM company actually gets. If you didn't tune in to last time's webinar, I invite you to do so, or to have a look at the ebook, because we looked in some detail in that webinar, didn't we, Raj, at the Supreme Court decision in First Port and Settlers Court. And that deals with who's responsible for the provision of the shared estate services and who collects the cash in relation to the provision of those services. So that this definition of premises and what or how far the RTM company can go in relation to what it manages, that's really important. So if you haven't caught up with that webinar, go and have a look at it.
So, Cass, so this is really helpful. You've described a very technical and procedural route, so non-fault. If the qualifying criteria are a mess and the right forms of notice are provided, then the leaseholders are able to obtain the right to manage. But would it be fair to say that some of the challenges around RTM don't come from the technical requirements, but in fact the people who end up taking over the management function of the building? So do you have any words or thoughts on some of the challenges that may be faced, whether through a dominant person or inactive people or other?
I think it's important with any lessee owned and controlled company where the directors are resident directors that they understand what their duties are as directors, and understand what the implications are in relation to the memorandum and articles of association of the company, so how they're to behave as directors, but also what the Companies Act says in relation to these things, because Companies Act applies to RTM companies as equally as it applies to residence management companies that are written into tripartite leases. It's really, really important that before somebody signs up to be either a member of a company or indeed a director of a company, that they understand what their obligations are and what they're getting into. I think that's sometimes where things fall down, isn't it? That people haven't quite understood what their role and responsibilities are. So do some research beforehand before you sign on the dotted line.
We have in a prior webinar, and I can't remember now which it was, I think it was a couple ago, covered off Companies Act requirements, and all of the historical webinars that we have put together with Cass are available from the Fixflow website, so you can watch them on catch up if you wish, and that'll be available to you. My colleague Remy is about to scribble down exactly which one it was, but Cass, I'm just conscious of time and the amount we have to cover off. Is there anything else that you would like to cover off on RTMs before we move on to some recent cases?
No, I suspect there'll be some questions, but we can pick those up at the end.
Excellent, thank you. And so, ground rent case. This is really interesting, or at least interesting for legal geeks like me and Cass, because it covers off imputed knowledge of prior landlords. Would you like to just give us a quick summary of the case and I guess the key parts that matter to managing agents?
Yeah, I thought I'd mention the case because we have the Leasehold Reform Ground Rent Act 2022 that's now with us, isn't it? And that's the Act is the first in a series of proposed reforms relating to residential leasehold properties. And it follows pressure on the government, doesn't it, that we're all fully aware of, to deal with onerous ground rents. And the Act limits the ground rent chargeable on most new long residential leases to 1 peppercorn per year, so effectively reducing ground rents to a zero financial value. And the Act also prohibits payments of administration fees in relation to peppercorn rents. And the Act gives the local weights and measures authorities, trading standards, and in some cases district councils, the power to enforce any non-compliance with the Act. So they can impose financial penalties for breaches on landlords and former landlords, and those financial penalties range from £500 to £30,000 per lease. So they can be quite, use the word onerous, I'll use the word onerous again, onerous financial penalties for non-compliance with those. And you also have under the Act the anti-avoidance measure, so the amendments that's been made to Schedule 11 to the Common Hold and Leasehold Reform Act 2002 to ensure that no administration charge is payable in the collection of any ground rent that's restricted to a peppercorn by the Act. And leaseholders will be able to apply to a tribunal for a determination in respect of those as well. So that's where the ground rent case came from, but the ground rent case is all about service of ground rent demands, where the reversionary interest has changed from landlord A to landlord B. Full details of the ground rent case will be in the ebook that's generated on the back of this. So if you are a legal geek like Raj and I and interested in that, then full details will be there. But it's important to make sure, I suppose the message of the case is important to make sure that you are serving your notices on the correct addresses, because in this case, the landlord didn't, they weren't served at the correct address, so those were deemed to be invalid notices and the ground rent wasn't payable as a result. So the message, make sure you're serving your stuff at the correct addresses. It talks about imputed knowledge and stuff like that in the case, which if you're a legal geek, you're going to love, but message, serve at the correct address.
We're going to go on to a Section 20 case, and in my head, this is a bit like, sorry, this is going to be a slight ramble, but watching Who Wants to Be a Millionaire, and someone saying, well, the answer is really obvious. The answer is obvious if you the question's easy if you know the answer. So this case concerns leaseholders nominating an underqualified contractor. So I suspect a lot of you will be screaming at the screen. You know exactly what the answer is. But for those who don't, what was the case about and what should people do?
People do need to know about this case. It's an important case where landlords or agent acting on behalf of landlords or management company are undertaking consultation in accordance with Section 20, as supplemented by the 2003 regs in England, 2004 if you're in Wales. And we know that consultation is a staged process. So you send your notice of intention to carry out the works, and that enables leaseholders or any recognised tenants association, if there is one, to make observations in relation to those works that are proposed, and also to nominate possible contractors who could carry out those works. And this case is all about contractor nominations. You then, if you get observations, you have due regard to those. If you get nominations for contractors, you then go out and obtain a quote from the nominated contractor. So that's stage 2, which is the estimate stage. So the landlord will be seeking estimates for the works, including any nominee that's notified or identified by the lessees or the recognised tenants association. You then, on the back of that, I'm old, I remember when we used to call these paragraph B statements. We don't seem to do that anymore, but we then send out the notice of estimates, and that's sent to all lessees and again to the recognised tenants association if there is one, and that will set out 2 or more estimates, a summary of any observations received at stage 1, responses to those, and any nominee's estimate must be included at that point. Again, observations invited, landlord to have regard to those observations, and unless the chosen contractor is a nominee or submitted the lowest estimate, then that's when you send the notice of award of contracts or notification of reasons, whatever label you want to attach to that. So that's a really brief overview of the process. And in Collingwood and Carillion House Eastbourne Limited, the Upper Tribunal considered whether that process had been followed. And what happened in Collingwood and Carillion is that back in November 2017, notice of estimate was sent out to all lessees. There wasn't a tenants association here, but notice of estimate sent out to all lessees regarding an external redec project. And that invited observations and invited nominations in relation to contractors. Everybody agreed that that notice was okay, that it complied with the consultation regulations. In response to that notice, one of the lessees nominated a company, so nominated a contractor. Incidentally, he was also the sole director of the contractor, but by the by, the landlord didn't get a quote from that nominated contractor. Landlord instead, several months after, sent out their notice of estimates containing 2 estimates, neither of which were from the nominated contractor. The lessee wrote to the landlord saying, hang on a minute here, what's happening? Why haven't you approached my nominated contractor? And the landlord then did so. The contractor didn't fill in the form that the landlord wanted to be filled in. So they'd been asked to complete a form of tender. They didn't do that. So hadn't provided a costed schedule of works. So essentially that contractor, albeit they were approached after the event, hadn't done what the landlord wanted them to do or how the landlord wanted them to do it, so they were ignored. There was a bit of toing and froing between the leaseholders and the landlord, as there is sometimes, and a fourth contractor was eventually appointed, and leaseholders were asked to pay just over £5,000 each. The leaseholders, or certain of the leaseholders, then made an application to the tribunal for the tribunal to determine the reasonableness and payability of the service charges. And what the leaseholders were arguing is that the Section 20 process hadn't been followed. Hadn't been followed because the landlord hadn't obtained a quotation from the nominated contractor, so from the nominee, and that the landlord had therefore failed at the statement of estimate stage because that hadn't been a correct estimate. They'd not gone and got the nomination. The first tier tribunal decided, well, the landlord's tried. He's made a bit of a go of it. So, he's endeavoured to carry out some consultation, and on the basis endeavoured to carry out some consultation, there might have been a few shortcomings, but it's all right. Decision of the first tier tribunal. The upper tribunal took a slightly different view to the first tier tribunal on this one. And the lessees in the upper tribunal argued that consultation is a sequential process. Mm-hmm. And that because it's a sequential process, the consultation regulations require the landlord to try and get the estimate from any contractor nominated by a lessee. The landlord said, well, the consultation regulations require us to consult, and we have consulted. And in any event, the consultation regulations, say the landlord, are a bit woolly, which was an interesting comment to make to an upper tribunal judge. The upper tribunal judge took a slightly different view to the landlord and agreed with the lessees, saying that the consultation regulations are strict, they are sequential, and that there is no room for flexibility in their interpretation. They said they are anything but woolly, despite the suggestion from the landlord. And the tribunal said that the notice of estimates cannot be given until the landlord has tried to obtain a quote from the nominated contractor. Because the landlord in this case hadn't done that, the statement of estimates didn't comply with the consultation regulations. So the landlord was in breach of those consultation regulations and therefore capped, because he hadn't applied for dispensation, capped at recovering just £250 per lessee. So it's really, really important, because I know that agents sometimes get nominations made and those nominations might be discounted for a variety of reasons. I understand, I speak to agents, I see where they might be coming from with those. But the important point is that if you do get a nomination, then the consultation requirements and the regulations are strict and sequential. If you get a nomination, you go to that person nominated and you ask them to quote or tender for the works. If you don't do that, you will likely be in breach of the consultation regulations, and you'll likely be giving me a call to ask me how you get dispensation from consultation. So please, please, please do make sure, even if you get a nomination that you don't think will be able to do the job for whatever reason, but you go out, you get a nomination from them, you include them within the statement of estimates, and your place for discounting them is at the stage 3, which is the notice of award of contract stage. So really, really important.
Excellent. So don't filter at the outset. Get the estimates. Thank you. And now,
I think I've been saying hashtag don't ignore Bob.
Don't ignore Bob. I like that. Okay, the Building Safety Act, there is a lot of information. There is a lot more information to come, and there is still continued debate about what some of the detail we already have actually means. So we're unlikely to be able to do full justice, and I suspect this will end up being chunked over several webinars over the coming months. But Cass, what are the key points that you want to talk about today in terms of the Building Safety Act?
As you say, Raj, we are never going to be able to do justice to this within the short time frame that we have got. It would take days to be able to do so. So this is just intended to be a very cursory dance over what some of the key points with Building Safety Act are, and we'll come back to this in future webinars, as you say. But Building Safety Act 2022, I'm talking about Building Safety Bill for a couple of years now, but the Building Safety Act got its royal assent on the 28th of April of this year. And it is largely drafted as what lawyers would call enabling legislation. So it sets out a framework, but there's going to be lots more secondary legislation that comes in underneath it. And I understand that when I speak to people and they ask me questions, I say, I can't give the answer yet because that's coming in regulations, it's coming in secondary legislation. And I get the frustrations that people have with that, but there's a lot of detail to come, and that's going to be set out in regulations. So just because we have the Building Safety Act, that's by no means the end of the story. There's lots more to come, so you do need to keep a watching brief over what's happening with Building Safety Act. And the Building Safety Act provides for the building safety regulator within the Health and Safety Executive to oversee building safety through design, construction, and occupation phases of a building. So in our world, what we're probably most concerned with looking at is Part 4 of the Building Safety Act. And it's Part 4 that contains provisions about the management of building safety risks in occupied higher risk buildings. And so it defines what a building safety risk is, what a higher risk building is for the purposes of Part 4, sets out who's responsible for building safety once a building's occupied. It provides for registration, so there's a registration requirement in relation to a higher risk building, and it lays down the framework for ongoing monitoring of building safety by the building safety regulator as part of the HSE, and that's via building safety or building assessment certificates, sorry. It sets out duties that people have, including residents, and those duties to the duty holders have regarding assessment, management, and provision of information on building safety. As I say, it requires engagement with residents in relation to high risk buildings and sets out the duties that residents have. And it provides a framework for the enforcement of those building safety duties. So it does an awful lot. But as I say, there's an awful lot more that's going to come in regulations and secondary legislation. So just to break some of those down a little bit, to make it a little bit more digestible. So the Building Safety Act defines what a building safety risk is. And for these purposes, for the purposes of Part 4 of the Building Safety Act, a building safety risk is a risk to the safety of people in or about a building arising from either spread of fire, structural failure, or any other matter that the Secretary of State might prescribe in regulations after consultation with the building safety regulator or anybody else they think appropriate. So those are the three elements of what a building safety risk is. The Act and Part 4 of the Act also defines what a higher risk building is. And that's a building in England that's at least 18 metres in height or has at least 7 stories and contains at least 2 residential units. And I know that there's in guidance out there, there's a lot of pictures of buildings as to how you measure your building. So that can be found. And Raj, I'm sure that we can help people with that if they want to see those pictures. In relation to who's responsible for building safety in occupied higher risk buildings, that's a duty holder called the accountable person. And the accountable person is responsible for the statutory obligations imposed by the Building Safety Act in relation to occupied higher risk buildings. And in addition to that, there are also, as I say, duties and obligations imposed on residents. Now, the Act sets out who the accountable person is, and there could be multiple accountable persons in a building, depending on how it's structured and essentially how the title is structured as well. The accountable person is the person responsible for building safety risks when a building is occupied. The accountable person might be an individual, might be a partnership, it might be a corporate body, and as I say, there may well be more than one accountable person for a building. I'll set out in the notes and in the ebook that follows who the accountable person could be. But if there is more than one accountable person, then you will have a principal accountable person. So if there's only one, then that person is also the principal accountable person. If there are multiple accountable persons, then you will have a principal accountable person.
So we just had a question flash up that I think it's worth answering in line. Could you just repeat the 3 building safety risks, please?
Certainly. So the definition of what a building safety risk is.
Yes.
Yep. It is spread of fire, it is structural failure, and it is any other matter prescribed in regulations by the Secretary of State. So a building safety risk for the purposes of Part 4 is a risk to the safety of people in or about a building arising from spread of fire, structural safety, anything else Sec of State might prescribe in regulations after consultation with the regulator or anybody else they think appropriate.
Given that there is so much in here, should we focus in perhaps on some of the key areas, like the building safety charge, external directors, and perhaps the waterfall? Would you be happy to talk through those elements?
Yeah, if I can just...
Of course.
Sorry, Raj. Put me on the spot there with that one.
Sorry.
Just to finish off what we were saying about accountable person and principal accountable person, because I suspect that many management companies watching this are going to be accountable person or principal accountable person, and we will have a number of agents watching this on their behalf who will be acting as agent for and on their behalf. So the principal accountable person is going to have to ensure that the building is registered with the building safety regulator before the building is occupied. Buildings which are already occupied will have to be registered within a transitional period that comes into force. Each accountable person is going to be responsible for assessing the building safety risks, and we've looked at what those building safety risks are, and that duty to assess is an ongoing duty. So you can't just assess once and then put it on the shelf and forget about it. This is an ongoing duty that you have. So the assessment is going to have to be made at regular intervals, as soon as practicable after it becomes occupied. If you've got reason to suspect that the assessment is no longer valid, or if the regulator tells you to do so. Your accountable person is going to have to manage the building safety risks for the part of the building for which they are responsible. And that means promptly taking action or reasonable steps to prevent a building safety risk materializing and to reduce the severity of any incident resulting from such a risk. The accountable person is going to have to prepare a safety case report for the building. They are going to have a mandatory occurrence reporting scheme to the building safety regulator. They are going to have to keep and provide information about higher risk buildings. So this is the golden thread that people have probably heard a lot about over the last couple of years, the golden thread of information that runs through the lifespan of a building. And there's going to be much more in regulations that come out in relation to that. The details of the requirements are going to be set out in regulations. So far as engagement with residents is concerned, your principal accountable person is going to have to prepare a strategy for promoting the participation of residents and flat owners in building safety decisions. And there will be the type of information and the form of that information is going to be provided in regulations. There is a consultation ongoing at the moment just to flag in relation to higher risk buildings. We'll set out the link in the ebook that follows. It's a consultation that ends, I think it ends next month in July, but that's consultation on what a higher risk building, or what should constitute a higher risk building under the Building Safety Act. So if you have any views on that, then your responses by the 21st of July. It got published on the 9th of June, so it's been open for a week or so now. But as you say, Raj, there are lots of elements of the Building Safety Act, and there's lots of secondary legislation that's coming down the track as well. The elements that we haven't touched on yet, and I don't know whether it's a conversation for perhaps next time, are costs and cost recovery, because that seems to be one of the biggest questions that I get asked. We have all of these duties, how are we going to recover the costs associated with the performance of those duties? How are we going to recover the costs associated with the carrying out of any remedial works that might be required? I don't know what you think, Raj. I'm probably taking over your role as presenter here, but I don't know whether it's worth asking people what their questions are in relation to those, so that we can perhaps put them together and look at those.
I think that dealing with that as a separate topic in the next webinar would be great. And so please, again, if you've got comments, questions, put them in via the Q&A. We've had quite a few in on section 20, which I wasn't expecting, actually. So I think we'll go back and cover some of those off in the Q&A section. But in terms of recovery of costs under the Building Safety Act, including those of remedial works, please let us know what you're seeing, what you're thinking, and we'll do a topic specifically on that.
I think just to mention that we when it was published in draft, the draft bill, we'd expected there to be a separate building safety charge.
Yeah.
And initially this had been expected to cover all sorts of things. It was then pared back an awful lot, so that it specifically excluded the cost of remedial works and was just generally in the running and management of the building safety side of things. Building safety charge as a separate charge has now gone, but there are provisions within the Act that expand what a service charge is. So it's essentially been amalgamated into the service charge regime. But
that's got to be the right way, though, because there is sufficient case law and understanding of how service charges work that a whole new regime from the start would have been fraught with complexity and uncertainty. So my view is that's to be applauded, and it keeps things simple because it's a framework, and a framework that is well understood and well tested that is being applied.
Yeah. And if you have a separate regime, then you're doubling the expense because you're accounting for it separately, you're demanding it separately, you're holding it. It seems a sensible way that it has now been amalgamated with what we know and love as a service charge.
I would say no, not necessarily love, but definitely no. In terms of external directors, so as obligations increase and consequences also increase, what's the approach around getting external professional directors in? Do you have any thoughts both on who those may be, but also how they may have their costs met?
I think this comes on the back of concerns that probably most of the industry have from time to time regarding the ability to recruit directors for lessee owned and controlled companies. And I get that it's a challenge. I hear those challenges on a really frequent basis from my clients, that they struggle to find people to be directors. Under the Building Safety Act, there are a number of criminal offences that are committed by a company and every officer of that company who is in default. So if you are having difficulty now recruiting directors, I suspect those difficulties without this provision under the Building Safety Act may have become increased because of the criminal liability that attaches to companies and every officer in default under the Building Safety Act. So on the back of that, there has been provision made within the Building Safety Act where companies are lessee owned and controlled, so your residence management company, your RTM company, for them, notwithstanding anything that's in the lease and notwithstanding anything that's in the company's memorandum and articles of association, because sometimes that locks down who can be a director, but there's provision within the Act for them to appoint essentially a professional director and to recover the costs associated with the appointment of that professional director via the new service charge mechanism. So again, it overrides what might be in the lease, it overrides what might be in the Memonarts, and allows that external professional director to be appointed.
And who will that be?
I suspect that we will suddenly see a new industry jump up of professional directors.
I think that may well happen. Is it
Would you be one, Raj?
Probably not, actually. What would you?
Probably not.
No.
The criminal liability, isn't it?
Yeah. Is it? I'm conscious of the number of questions we have, and again, loads on section 20. So I feel like we're going to have to go back through a bit of that, and there's some really interesting points being raised. Is it worth us talking about the waterfall funding mechanism, even at a high level? Because I suspect if we don't, then we'll get various questions about it and come back to it anyway.
I don't know whether we have time to do that at a higher level, but certainly at a really, really high level, the Act sets out who is going to be the first port of call for any costs associated with remedial work. So it is developer, cascading down to building owner, and then cascading down to lessees, subject to a cap.
Mm-hmm.
What we'll probably do for next time, Raj, is to maybe within the slides, because it's easier to explain this when you have the slides in front of you with what those caps are and what they look like. But yes, there are provisions there to ensure or to give effect to what the government say, that leaseholders shouldn't be paying for this stuff. And it depends whether we're dealing with cladding defects or non-cladding defects.
I guess in passing, should we talk about PEEPs and their requirements? Because I think that's an important factor for people on the call.
Yes, there's always lots of questions about PEEPs. So the consultation out at the moment, forgive me, I think the consultation finishes mid-August about what the requirements should be in relation to PEEP. So if you haven't had opportunity to have a look at that consultation and you do have something to say about it, and lots of people do, then please do submit your responses to that consultation.
And we've referred to them as PEEPs, as personal emergency evacuation plans. Sorry for using an acronym and not explaining it at the start, that was my bad. Shall we go on to the questions? And I think I'm going to spend a bit of time on section 20, and thank you very much for submitting some questions in advance as well to everyone who did. A very pertinent one, given the high inflation environment we're currently in. Costs are rising and quotes are no longer being held. What happens if we get the residents to agree a cost and the prices have changed?
So you go out for your section 20 consultation and your stage 2 says we have obtained 2 estimates and the estimates are 200,000 and 220,000, and you go for the lowest price one. Yep. But by the time that you've collected the cash from the lessees on the back of that, the 200k has gone up to 250k, if not more.
Yep.
The scope of the works hasn't changed.
No.
So the scope of the works that you set out in your stage 1 notice is correct. Your statement of estimates, and it is an estimate, has gone up because of inflation. I suspect you'd be okay, although I say that without any upper tribunal authority on my side.
No, and that's the bit that's missing in this, isn't it?
Yeah.
Okay. I'm gonna.
If in doubt, go to the tribunal and get a determination.
Yes. I'm going to go through some of the questions. I think they're quite overlapping in terms of the questions that are being asked about RTMs. You said earlier that one RTM cannot manage more than one block within the same development. Did I understand that correctly? Is what I'm going to summarize 3 of the questions that come in as.
Yes.
Yes. Are there restrictions on the type of company which can be used for an RTM?
Yes. Yes, and it has to be. It has to be an RTM company, and it has to adopt the model articles for an RTM company as well.
Does it have to be named in a particular way?
And there was a case on that actually as to whether because it didn't have RTM in the title of the name of the company, it wasn't actually an RTM company. No, the landlord lost on that one.
And how are lessees changed as members of the RTM over time? So how does the living corporate entity change?
Oh, so lessees can, the Memo Notes prescribe the participation application that the lessees should use if they want to become a member of the RTM company. So as flats change hands and are sold, then incoming lessees, if they choose to become a member of the company, can do so, and they just complete the participation application and send it to the company. And the company obviously then updates its register of members, because it has to do so under section 113, and it's a criminal offence if it doesn't.
We touched on the uncommitted service charge funds being transferred. What about the documentation and any historical information about the building? What is the process for getting that, and what happens if it's not handed over?
That's section 93. So the accrued uncommitted service charge funds is section 94 of the Act. The duty to hand over documentation is section 93. And it's the documentation that the RTM company reasonably requires in order to exercise the right to manage in relation to the premises. You would normally serve a section 93 notice, giving the person 28 days, that's prescribed by the Act, to hand over those documents that the RTM company reasonably requires. If they don't, and don't do so within the timeframe set down by the Act, then an application can be made to the county court. So it's court that you go to for section 93 rather than the tribunal.
Okay, and I guess the practical question around this is, what sort of backlogs are you seeing, I guess, both at tribunal and at courts at the moment? So how practical is it to get the exercise of justice and the exercise of rights?
There are backlogs. I think it's fair to say there are backlogs. Anybody that is involved in either court or tribunal proceedings will be nodding along with me and going, yep, there are some backlogs at the moment. I think that the court, I'm trying to think the last time that I read the court stats, probably a few weeks ago now, in terms of small claims, because a lot of what we deal with is small claims, isn't it, service charge recovery. But just to give you an indication, I think the average from claim being issued to trial on a small claims matter is now just under 51 weeks. At the start of the year, it was 52, 53 weeks. That's a long time if you need that cash to be able to provide services. Yeah.
I'd love to hear from anyone in the audience who's experiencing anything markedly different from that, but 51, whether it's 51 or 52 weeks, that is astounding.
It's a long time, because the service charges, if we're dealing with a service charge case, for example, will have been in arrears for a period of time up until that point, because they would have been demanded, there will have been some internal credit control, there'll have been an LBA, so it'll be a good 2, 3, maybe even more months than that before the claim's issued.
Okay. We're going to move on to section 20, if that's okay. What if a nomination is made and the contractor is discounted because, for example, they aren't adequately insured?
Don't care. Go and get a quote from them. Discount them at the award of contract stage.
But if you have it, and I guess this is a secondary point, but if you've invited them to quote and they have failed to do so, you have discharged your obligation. So even if you don't think they are likely to respond, if you don't think they are appropriate, let them prove that either by not responding or by proving themselves inappropriate. You can't filter them at the start.
There is no room for flexibility. If you have received a nomination, you go out and you try and get a quote from that person that you've received the nomination about. The regulations set out, it's an arithmetic way of dealing with it if you have more than one nomination. So you need to have a look at the regulations for that. But if you do get that nomination or do get some nominations, you need to approach them. You can't just discount them. You certainly don't discount them at the statement of estimate stage. You deal with the appropriateness or otherwise of them at the notice of award of contracts.
I'm going to conflate a couple of questions. Hopefully that's okay to the people who've asked them, which is effectively, if you are undertaking some works following section 20, but then find that other emergency works are required without such time as to be able to go through a consultation, what should you do?
Depends on the extra works that you've found. So there's some case law on this, and the name of the case escapes me, but I'll remember it by the end of the webinar. And it was all to do with roofs and whether the addition of a pedestal meant that they needed to go out and do stage 2 again. And the tribunal said that they didn't, because the works were largely similar to what was already being undertaken. It depends what you find. If you do find that there are things to do that are not part and parcel or couldn't be argued as being part and parcel of what's already being undertaken, then go and get dispensation and get emergency dispensation. Because
Okay.
you can go to the tribunal and ask the tribunal to grant dispensation from consultation on an urgent basis. It may be that in those kind of circumstances you get conditional dispensation rather than full dispensation, and the kind of conditions that might be attached to it are that you have to communicate with all lessees and tell them what's happening and tell them about the updated costs. But if in doubt, then an application under section 20ZA to the tribunal for urgent dispensation from consultation, probably acknowledging in the application that it may well be conditional dispensation that's granted.
Thank you. We're going to move on. And sorry, we haven't been able to cover off all of the questions thus far on RTMs and section 20, not least because they've continued to come in. So again, we will see what we can do in terms of answering them, and there will be a follow-up ebook circulated, which hopefully will cover off a lot of the questions. In terms of building safety, I guess the first question is, when will external directors come into force? That's been asked by a couple of people.
Not sure. I'll come back to you. I'll see if I can find out.
We've had some requests for other things to cover. In future webinars, there's a question around insurance cover for managing agents for dealing with fire safety matters. What are your thoughts on that? Because without appropriate insurance cover, it all becomes a bit moot.
Yeah, I'm also always really interested about insurance where managing agents are acting as company secretary as well, given that offences are committed by the company and every officer in default and the co-sec is an officer of the company. An interesting one. I'm not sure that I have a view from an insurance point of view on that. You're probably best off asking somebody that specialises in insurance or an insurer.
We may get their input for the next webinar, I think. So that's a key point.
Yeah. But it's a really important point.
Does structural failure also include essential M&E, e.g. AOV systems?
Whether that will come out in regulations.
There's going to be a lot of detail in the regulations. That's kind of the way this seems to now work. You get high level information in the Act, and then a lot of the rule making and actually the rules are put forward through statutory instruments, regulations and the like. A follow-up question, which I think is useful on section 20, is there a time limit on how long you give a contractor to provide a quote? So if a contractor is non-responsive, how long do you give them?
There's not. No, nothing in the regulations, either 2003 or 2004, depending if you're England or Wales. Nothing in case law either. The only thing in case law that talks about time limits is it says that consultation should be measured, or the consultation exercise should be measured in months rather than being measured in years. It's a case name that I can never pronounce.
Okay.
But I'm happy to share it with you. I just can't pronounce it.
Thank you all very much. We've managed to cover a lot of ground. I think we're going to keep coming back to the Building Safety Act and subsequent regulations. As promised, here is something shiny and new. If you could take out your phone and connect with me, Cass, both of us on LinkedIn, that would be awesome. It would also just be quite nice to see people popping up, and that would be great. I'm going to go back a sec. So quick update. So Cass, we had the Oxford weekend not so long ago. Have you got anything else in the pipeline?
Yes, we have our Oxford weekend of 2023. So we're back at St Hugh's College in Oxford, which is one of the Oxford colleges. If you haven't been to St Hugh's, it's beautiful. We essentially take over the college for the weekend, and we stay in student accommodation, we have our conference there, we dine at St Hugh's, and we take over the student bar at night as well for our school disco. So we're back at St Hugh's next year over the weekend of the 31st of March to the 2nd of April. So save the date. Tickets are likely to go on sale early autumn.
Amazing, thank you. And some interesting, hopefully exciting news for everyone here. industry advisor to Fixo, Nigel Glenn, who is also the exec chair at the TPI, is going to be taking over as the host of this webinar alongside Cass. We think that his expertise, knowledge, and experience of the block management sector is hugely valuable, and hopefully he will provide a different change of pace across these webinars. It's been an absolute pleasure hosting these, and particularly having the chance to speak with Cass. And from the next quarterly updates, it will be Dr. Glenn. Thank you all so much for attending. Thank you again, Cass, for all your preparation, hard work and presentation. If you haven't already connected with us, I'm going to go back. I'm very excited about this. I've never seen it before. Please do connect with us on LinkedIn. We're going to send you a follow-up email and an ebook, and you'll also get information about service charge recovery as well. Looking forward to being a viewer next time rather than the host, as Dr. Glenn takes over very capably, no doubt. Thank you all so much. Please provide us with feedback. Your feedback shapes what we cover, the level of detail and everything else. So please take a moment at the end of today's webinar to give us your feedback and your thoughts. Thank you all so much. Thank you, Cass. Have a wonderful Tuesday, everyone.
Thank you. Take care, guys.
Thank you. Bye.